Good morning, ladies and gentlemen. Our first case is 2020-277, the Cleveland Electric Illuminating Company versus the City of Cleveland et al. For the appellant, cross-appellant, Mr. Phillips.
Good morning, Your Honors, and may it please the Court. I'm Greg Phillips for the appellant, the Cleveland Electric Illuminating Company, and I wish to reserve 3 minutes for rebuttal. This is a constitutional case. By its own actions, the City of Cleveland has created an artificial surplus of electricity, and its sales to non-inhabitants under Hans, Britt, and Toledo Edison are unlawful. A ruling enforcing those precedents will not in any way affect Cleveland's home rule power to provide service to its inhabitants. Not enforcing them, on the other hand, would disrupt the state's regulated electricity markets and ultimately harm Ohioans across the state, allowing municipalities to unfairly compete by cherry-picking the largest customers with discounts.
Now, Counselor, what's the evidence that the surplus Cleveland has or uses was artificially created?
The evidence, Your Honor, is that the City of Cleveland generates virtually no electricity and hasn't since the 1970s. CPP purchases virtually all its electricity in real time, and it hasn't. It tailors its purchases to actual demands, buying no more than its customers actually consume. Third, a very high percentage of its purchases, some 45%, are made under requirements contracts. In contrast, only 3% of its sales outside the city are outside the city. CPP can comply with the Constitution simply by reducing its requirements purchases to exclude its non-inhabitant customers. Indeed,
so it's not CEI's assertion then that the city is in violation of the Constitution simply because it has these contracts outside the city.
It is also the step of purchasing the electricity and then selling it to non-inhabitant customers like Brooklyn. Indeed,
but having the agreements in and of themselves don't constitute a violation.
Having the agreements in and of themselves don't constitute the violation. The violation is purchasing more than is needed for the inhabitants of Cleveland. It's buying excess electricity under its requirements contracts, which it can easily avoid, and then selling it to non-inhabitants.
Okay.
Indeed, the undisputed expert testimony was that CPP need never obtain or maintain any excess supply of electricity, and CPP doesn't dispute that it can purchase only the kilowatt hours it needs for Cleveland. I want to take a step back and give the court a roadmap for my argument. CEI respectfully requests that this court do 3 things. First, this court should overturn the 8th District's other purposes doctrine, which it devised out of whole cloth. It has no basis in the constitutional text and is expressly foreclosed by Britt. Second, the court should reverse the 8th District's denial of summary judgment for many of the reasons I just discussed. CPP sells to non-inhabitants only because it wants to, not because it has to, and certainly not because of a compelling necessity to do so. The Constitution grants CPP no power to engage in discretionary sales outside the city. Any sales to non-inhabitants must be necessary and unavoidable in operating a municipal utility to supply to its inhabitants, the sole purpose authorized under Article 18.
And what's your authority for that it has to be necessary?
The authority, Your Honor, is Britt and the text of the Constitution itself. The other purposes doctrine, Your Honor, suffers from 3 fatal flaws. It contradicts the plain language of the Constitution. The test is ripe for abuse, and it would be all but impossible for the lower courts to administer. First, the Constitution. The plain language of Section 4 authorizes only one legitimate purpose for a municipal utility to purchase electricity. to supply it to the municipality or its inhabitants. And Section 6 reiterates the same sole purpose. Neither section contains an express grant of power for other purposes, nor can such a power be found by implication for two reasons. First, the constitutional text has to have meaning. Allowing sales to non-inhabitants for unenumerated other purposes will eviscerate all meaning from the words chosen by the framers in Section 6 for the purpose of supplying the municipality and its inhabitants. And if the words chosen by the framers aren't given effect, it will greatly expand municipal power in a way the framers never envisioned. Second, Britt forecloses any finding of an implied power in this case. Any implied power requires a compelling necessity. It can't be inferred merely because it's economically or politically advantageous or for the city's convenience or economy. But the other purposes doctrine inverts Britt's analysis. It affirms implied powers precisely because they're economically advantageous or convenient for the city. The test also encourages municipalities to use pretext to obscure the real purpose for brokering to non-inhabitants, which is to make money. Remember, the PJM wholesale markets have taken virtually all the economic risk out of brokering. Now, if not reversed, the other purposes doctrine would greatly erode the only legal barrier to brokering. The predictable result will be much more brokering and fact-intensive litigation over municipal motives. But how are the lower courts supposed to apply?
Counselor, you keep calling this a doctrine the 8th District adopted, but as I read it, the 8th District largely did what you wanted them to do and said that Cleveland could only purchase power for the purpose of supplying its customers, and then had some kind of broad language about things that might be looked at as part of purpose, and some of them would seem hard to argue with. Things like reliability and a long-term purchase contract. I think we'd all agree that that's something that might be part of purchasing for your customer for the city, and you may have some excess of point. Economies of scale. Certainly, if the city could purchase electricity cheaper under a certain contract, I don't think there's anything required to spend more money than it has to. So I guess I'm trying to understand how you come up with that there's some new doctrine here instead of just asking us to affirm the 9th District, but more narrowly tailor what it said.
That is in essence what we're asking, Your Honor. But those factors, those considerations that you raised, economies in scale, reliability, those are all fair factors to consider so long as the purchase is for the city and its inhabitants. If the city takes those factors into account, yet purchases the electricity for sale outside the city, that is unconstitutional, and that is what we've argued in our briefs.
But let me ask you, okay, that's helpful, thank you. Let me ask you, help me understand exactly what you want to do and then what happens. I mean, as I understand it, the only thing you asked for below on summary judgment was a declaratory judgment, essentially saying that Cleveland couldn't purchase for other than its own use, and any surplus essentially, if it could only be something that was generated for something that was unavoidable after Cleveland purchased for its own use. But all you asked for is a declaratory judgment, as I understand it. So in your view, this would go back for a trial where the court would determine exactly how that legal proposition applied to the facts? Is that what you're asking us for?
We're asking for summary judgment and the issuance of the declaratory judgment. And after that, I expect that the trial court proceedings will be limited to an injunction that will be tailored to the actual sales to non-inhabitants. So
there was no request for an injunction, right? You didn't move for summary judgments on an injunctive relief. So do you envision that there would be a trial on that, or what are you envisioning would happen?
I envision that on remand before the trial court will have the declaratory judgment, or will issue it. And then the sales to non-inhabitants will be examined, and the injunctive relief will be tailored specifically to CPP's actual conduct in selling to non-inhabitants. So it'd be my view is that it'll be a limited proceeding with respect to the injunctive relief.
Thank you.
Mr. Phillips, is it just Cleveland Public Power that purchases from PJM, or is that something that larger suppliers like First Energy also purchase from?
Larger suppliers like CEI purchases from PJM, but municipal utilities across the state are also purchasing from PJM. Essentially, all the major are also participants in PJM.
And so how do we deal with PJM's requirement that its buyers, according to contract, have to have a certain reserve, which necessitates buying more than exactly what might be needed according to projections?
Your Honor, PJM does require a capacity reserve margin. That is not the same thing as an energy reserve margin. The 8th District erroneously misconstrued the capacity reserve margin to be an energy reserve margin. Capacity is just the right to obtain or buy electricity if and when needed. It's not the same thing as kilowatt hours of electricity. This court in Hance, some 62 years ago, made clear that capacity is not the proper measure of a Section 6 surplus. Actual kilowatt hours supplied over a period of time is the proper measure. So CPP, by its own choices, has decided to participate in PJM, and as a requirement of that, it has to have a capacity reserve margin. But the key word is it's a reserve. It's a reserve for its existing customers that cannot then be reappropriated to sell to other customers. It has to be maintained as a reserve for existing customers so that if there's unexpected demand peaks at a particular time, it's ready to service them just like all the other participants.
One last question. In this market, is there any other wholesaler that CPP could buy from other than PJM? I just don't understand how these, PJM is a wholesaler. Is it assigned a particular market?
I believe that PJM is the one wholesaler available to CPP. I'm not aware of another one. Obviously, there are regional transmission organizations around the country, but I do not believe that CPP can participate outside the region.
Right. So if CPP chose, as you said, to use PJM, if it chose not to, what would its alternatives be to be able to supply power besides generating it itself?
Well, besides generating itself, that's a big but. But in addition to that, it could go back to bilateral contracts with suppliers and receive electricity that way. I believe that continues to be an option. But
it's not as cost effective though, is it?
It has inefficiencies that we described in our brief. Each transaction would need to be looked at to see how cost effective it would be for Synergy.
Thank you.
For CPP. Once the other purposes doctrine is overturned, there will be nothing left for trial, as I've discussed. Summary judgment should be entered for CEI on the record before the trial court, especially in light of finding of fact number 7. that CPP has the flexibility to increase or reduce its electrical supply through various contracts and commitments. CPP has never challenged this finding of fact. CPP has never even tried to show that it has a genuine surplus of kilowatt hours of electricity. Indeed, the undisputed material facts foreclose any genuine surplus. See that my time is up. I will reserve my remaining arguments for rebuttal.
Okay, keep in mind, Mr. Phillips, you've used all your time. Ms. Boyko.
Thank you. Chief Justice O'Connor, honorable justices, may it please the court. My name is Kim Boyko with Carpenter Lips and Leland. I am counsel for Appellees and Cross Appellants, the City of Cleveland and Cleveland Public Power. I would like to reserve 4 minutes of my time for rebuttal on cross appeal. The Ohio Constitution gives municipalities the express authority to own, operate, and regulate utilities. And this court has held that they may do so in a proprietary, business-like fashion, as your honors have pointed out this morning. There are only 2 limits on this express authority. One is set by the express language of the Constitution, and one by this court's interpretation of that Constitution. There are only, therefore, 2 questions that this court must answer. Whether the city has exceeded the 50% limitation set by Article 18, Section 6 of the Constitution in selling or agreeing to sell utility service or products to entities outside the municipal boundaries. And secondly, whether the city has purchased electricity solely for the purpose of reselling the entire amount of the purchased electricity to an entity outside its boundaries, as set forth by this court in Toledo Edison versus Bryan.
Counsel,
The answers to both of these questions are no.
Counsel, let me ask you a question. And I don't think the in excess of 50% is an issue here. But do you agree with Mr. Phillips' statement that the city intentionally purchases more electricity than is needed for its inhabitants?
Absolutely not, Justice Stewart. The city has what's called a supply portfolio, and the city's supply portfolio is made up of many different supply contracts. We have long-term, short-term.
But in that portfolio, isn't the contract, the long-term contract with Brooklyn part of that portfolio?
Your Honor, the portfolio is done in terms. So there's a 5-year term, and there are also annual supply portfolios. So what happens is we have to supply for existing customers at the time that the portfolio is put together. And a load serving entity is required to serve all of its customers with energy and capacity. Despite what CEI says, we are required to support capacity.
But don't those customers in that portfolio include the city of Brooklyn?
It depends on what time the portfolio is created, Your Honor, not necessarily. The city has to supply all of its residents. Right now, importantly, the city only supplies 1/3, and that means CEI supplies 2/3 of its residents.
Excuse me, Counselor, isn't it a 10-year contract with Brooklyn?
Your Honor, there is a 10-year contract that came into being in 2019.
So for the next 10 years, you have to, when you calculate how much you need, you have to take into consideration the amount you have to supply Brooklyn, right?
Your Honor, there's a couple things with the Brooklyn contract. Let me explain. There's a
It
solar project.
It seems like a yes or no question. Don't you have to, when you're considering what you need to buy for the next year, 10 years, don't you need to budget that you need to have enough to supply Brooklyn?
Your Honor, it's not as simple as you would think. It's not just a kilowatt hour basis. There's a capacity requirement and a distribution requirement.
Okay, fine, but can you choose not to supply? You have a contract to supply Brooklyn for the next 10 years.
We have a
You
contract
have
to
to fulfill
supply.
that, right? So you have to buy electricity necessary to fulfill that contract.
We have to build assets and create assets sufficient to supply the distribution service, the generation service, and the capacity service that goes to Brooklyn from 2019 on.
So the answer is yes. Then.
Well, I guess you really don't have to, because you could be in breach of contract.
Well, Your Honor, there are many parts of the contract. That's what I'm trying to explain to you. The contract was entered into in a 10-year contract because the city of Brooklyn asked the city to bury the lines. So that comes at a significant cost to the city. So in order to provide distribution service to Brooklyn for only one facility, one rec center right now, that facility had to have buried lines. And so in exchange for the cost of those buried lines, the city did agree to do a long-term contract, but they had to do it economically and at the benefit of all of its customers to make it cost effective. And
So
to
is
do
there-
that, they had to enter into a long-term contract for distribution
Is there
service.
ever a time then with that cost factor built into the contract, is there ever a time where the city of Brooklyn would have to continue to pay the city of Cleveland for those elongated costs over time, but not supply electricity?
Your Honor, as you pointed out, you can breach contracts, and the terms of the Brooklyn contract were not in the record in this case. Beyond what I've shared with you so far, there's always several terms, but the point of the contract is that it was entered into in order to make the provision of service to that customer cost effective and to build a solar project which brought renewable energy into the city. I think it's important for you all to know that the actual solar from the Brooklyn Solar Project enters CEI's distribution system. It does not directly serve the city of Brooklyn. So it enters it enters the city's distribution system, and it becomes part of the city's generation power. The city actually has contracts with AMP, which also creates an ownership interest in those generating resources. So the city enters into these contracts and actually has ownership interest in assets that create both generation and supply. And so when you enter,
if we agree with the Court of Appeals that the city wasn't entitled to summary judgment because this is really more about the creation of an artificial surplus, or whether the city's created an artificial surplus, is there evidence that the city has a surplus for any other reason than to supply the city of Brooklyn over its 10-year contract?
yes, Your Honor, both the lower court and the 8th District found that there was evidence in the record to show that the city has entered into a variety of contracts, short-term, long-term assets, and they also do generate their own power, and that all of those are done in a portfolio construct.
But I think both courts found that there's no way the city generates enough of its own power in and of itself, even to supply its own inhabitants.
That's correct, Your Honor. It is not cost effective for the city to generate its own power from its old power plants. So in order to construct new ones, we have to enter into arrangements to do that, such as the Brooklyn Solar Project, and bring in renewable energy into the city of Cleveland.
But does that violate the Constitution? Is it, as CEI is saying, you know, the municipal power isn't regulated, it then is unfair competition. Is the city flouting the terms such that if it creates an artificial surplus or it purchases more kilowatts than needed, and I think, and as Mr. Phillips said, just purchased in real time, then doesn't that allow the city to have more than it needs so that it can go out on the market and raise revenue?
Absolutely not, Your Honor. First of all, Section 4 of the Constitution specifically allows the purchase of electricity. It's generate or purchase electricity. Section 6 makes a limitation of that purchase and resale to outside entities. But Section 4 specifically allows it.
Section 4 allows purchase of electricity for use to serve customers of the city. It doesn't. There's nothing in Section 4 that allows a city to buy electricity solely for the purpose of reselling it.
Your Honor, Section 4 allows municipal utilities to purchase electricity that's primarily for the purpose of supplying its inhabitants.
Where does you find the word primarily in that Section 4?
Your Honor, that's the way that this court has interpreted Section 4 and Section 6. This court in Toledo Edison said, read in paramateria, Sections 4 and 6 allow a municipality to purchase electricity primarily for the purpose of supplying its residents and reselling only surplus electricity from that purchase to entities outside the municipality. This interpretation necessarily precludes a municipality from purchasing electricity solely for the purpose of reselling the entire amount of the purchased electricity to an entity outside the city's limits. That's in Toledo Edison at page 292. That's what this court said. And if it meant any amount.
Excuse me, but that's clearly the court didn't mean that as long as you can lump something into one big contract, you can, and the city uses some of it, that the city can engage in unlimited brokerage, right? I mean, it shouldn't matter for constitutional purposes whether the city purchases in one contract or two contracts or three contracts, or how it's all lumped together, right?
Your Honor, I think that the court in Toledo Edison used the facts of that case where there were 3 municipalities serving one entity outside, and it was the entire amount they purchased specifically to serve that one commercial customer. And that is not what's going on here. But it isn't unlimited, Your Honor. Section 6 does put a limit on it, and that protects against the unfettered competition that CEI is concerned about. And just for the record, the municipalities are regulated. They're very heavily regulated, despite CEI's assertion. But going back to whether the city needs to generate its own electricity, it does not. The city has a variety of assets and contracts, and they have to because it's required by the Regional Transmission Organization. They have to have these contracts to be able to serve any customer at any time based on their annual peak demand, which is the highest demand in 1 year. In order to do that, you have to make projections and forecasts. If a customer leaves and goes to CEI, then the city will actually have surplus at that time and they can resell it. A load-serving entity is required to purchase electricity and capacity, and building those capacity assets actually creates the energy that creates the surplus. There's no de facto brokering here. The city only serves one purpose.
Council, any excess, has that been attributed to customers leaving and going to another source like CEI or whatever else is available?
Your Honor, there is evidence both from expert witness Bentine and expert witness Williams that talk about the customers leaving the system and talk about the portfolio approach and how that would leave excess and surplus that could be then.
Right, and Council, I believe you said that in theory, that's what the basis would be. I'm asking you for any data. Do you have data that shows that any excess that's CPP had and then later sold was directly related to customers leaving your service for another provider?
Your Honor, there is data in the record. I didn't say in theory, I didn't believe. If I did, I apologize. There's record from expert witness Bentine and expert witness Williams that say that there has been people that come and go, customers off of the system, and that leaves from the portfolio approach that's purchased either 5 years in advance, 1 year in advance, depending on the type of contract, that would then create excess or surplus electricity that then could be sold.
Council, let me ask it this way. Assume you have a bad weather situation like we saw in Texas, only let's say it's summer and heat, so people want air conditioning. Without breaching the contract with Brooklyn, is CPP required to sell to Brooklyn instead of using that energy for its inhabitants?
Your Honor, there's a 15% reserve margin built into the contract, so the city is able to supply its customers. The city only serves one.
I'm saying an emergency over and above the 15%. I understand the 15%.
Right. I believe, Your Honor, because we're only selling 3% of our total load, that there would be additional power and surplus available to serve during a time of a cold weather event.
Well, I'm
There
saying a
is
warm
excess
weather
available.
event, and let's say it's 20 or 30% increase, okay? Can CPP stop providing electricity to Brooklyn and use that electricity for its own inhabitants without breaching the contract with Brooklyn?
Your Honor, every electric contract that I've done, I did not draft the City of Brooklyn one, does have various force majeure clauses and does have termination clauses. So I would expect that, yes, that could happen. The city is obligated to provide power to its residents, and it would provide power to its residents. The Ohio Constitution grants the city the express authority to sell the surplus products and services to customers
Boyko?
outside of the municipality.
Ms. Boyko, question for you. It seems that in your briefing that you want us to reverse or actually you want us to apply Toledo Edison, but it's the Hance decision that inserted the term primarily into the interpretation of furnishing services to city's own inhabitants. Wouldn't it be better just to look at the Constitution and use that, because the Toledo Edison case doesn't really square factually with this case here, and it's been 20 years, as the other side has argued. Wouldn't we be better just to simply apply the state constitution to your situation anew?
Yes, Your Honor, we fully support applying and enforcing the Constitution as written, and refrain from creating new law that nullifies part of the Constitution as requested, and reverse the 8th District's decision to reinstate the judgment of the trial court, where the trial court did in fact apply the Constitution as written. Thank you, Your Honors.
Mr. Phillips, you may take a minute.
Thank you, Your Honor. Just a few points on rebuttal quickly. First, there was a discussion of the Toledo Edison's court's reference to selling primarily to the inhabitants of the city. The existence of a genuine surplus is the sine qua non of any sales to non-inhabitants under this court's jurisprudence. In both Hance and Toledo Edison, the court reiterated the surplus requirement in the same sentence it used the word primarily. In Toledo Edison, the city was said that it could resell only surplus product from a purchase primarily for inhabitants. This court has never held that a city could sell artificial surplus to non-inhabitants so long as its operations were primarily to serve.
Mr. Phillips, let me quickly ask you, what constitutes legitimate surplus? I mean, how much over kilowatt hours needed for its inhabitants does the city have? How much of a margin is there? What constitutes artificial?
In this case, Your Honor, it's going to be a fact-intensive inquiry in each case.
Isn't that why we should affirm and send it back?
But in this case, there is no evidence that would support CPP's position that it has a genuine surplus. There was a discussion of the Brooklyn contract. Brooklyn has a 10-year supply agreement with CPP. CPP generates no electricity, but it's locked itself into supplying electricity to Brooklyn for a decade. Meanwhile, CPP's internal projections show a shortfall, the opposite of a surplus, over the same period of time. CPP can only perform that contract with artificial surplus by buying electricity for the purpose of selling it to Brooklyn.
But does it have to buy electricity for the purpose of supplying its inhabitants too?
Yes, Your Honor, and CPP can easily and readily tailor its purchases to perfectly match the demand of its customers.
Does the Constitution require a perfect match?
In this case, yes, because the kilowatt hours that CPP is selling to non-inhabitants are easily avoidable. They are purchased for the purpose and only for the purpose of selling them outside the city, and would not be purchased if the non-inhabitants were not customers of the city.
Mr. Phillips, how do we apply, whether it's Toledo Edison or Britt, as you say, or Hans, or the Constitution for that matter, with these issues, to this collaborative project for solar energy, where energy is actually going from Brooklyn to Cleveland as part of this whole sale arrangement?
Your Honor, CEI has absolutely no objection to the city's purchase of electricity from the solar farm, so long as that electricity is used to service the inhabitants of the city, which it can easily do. It can continue to purchase under its agreement to purchase from the solar farm and simply reduce its other purchases under its requirements contracts. Remember, 45% of CPP's electricity is bought under requirements contracts. The expert testimony is that CPP is able to meet actual demand and to adjust its purchases to meet actual demand, which ebbs and flows on a daily, if not hourly basis.
Thank you, Mr. Phillips.
Thank
Ms.
you.
Boyko, you've used your time. You may take a minute.
Thank you, Your Honors. By entering into long-term contracts for electricity, first of all, Section 4 of the Constitution allows the purchase, and by entering into long-term contracts, the city is doing so primarily to serve its inhabitants, and it is also allowed to consider other items to make it cost-effective under Sections 4 and 6 of the Constitution. By entering into these long-term contracts, the city is able to secure long-term pricing, stable sources of power, explore local generation opportunities where transmission congestion costs are mostly avoided, mitigate the cost of meeting its resource adequacy obligations by the regional transmission organization, and diverse its generation supply portfolio, including increasing the supply of renewable energy. That is exactly what the city has done in this case. The city is bound by the Constitution. It cannot contract around the Constitution. The Constitution allows it to sell outside its surplus up to 50%. The Brooklyn contract was not even an issue in this case in the trial court because the Brooklyn contract wasn't in existence. So it is a red herring in this case. The city has surplus power from its portfolio of purchasing. It cannot get out of the requirement contracts, as CEI would lead you to believe. AMP has very restrictive and strict terms and conditions, and the city is not allowed to sell or dispatch that electricity into the wholesale market. The bottom line is that CEI is trying to prevent competition, and they want CEI, the city, to sell on the wholesale as opposed to retail customers. And that is not part of the written Constitution, and it is not a preclusion of the Constitution or any court precedent. The court should apply and enforce the Constitution as written, refrain from creating new law that nullifies part of the Constitution, and it should reverse the 8th District to reinstate the judgment of the trial court. Thank you, Your Honors.
Thank you. Thank you. We will take the matter under advisement. You'll be notified of our decision.
Thank you.
Our second case this morning is 2020-485, 2020-826, the State of Ohio versus Brooke E. Jones. For the appellant, Mr. Galliard. You'll have to unmute yourself.
Sorry about that. Good morning, Chief Justice O'Connor. May it please the court, reserve 5 minutes, please. Ohio's statutory scheme governing reserved prison terms for community control violations require notice of the exact length of the reserved prison term when community control is imposed. So at the sentencing hearing, when community control is imposed, there must be notice for the specific prison term that's going to be held in reserve. And if that reserved term is imposed after a violation, its length shall not exceed what was provided in the notice. Given those statutory mandates, the exact notice must include a consecutive imposition.
So
Five
Counselor,
revised sections.
excuse me, let me ask you. So as I understand it, based on our case law, the judge can't impose consecutive sentences unless he or she makes the findings at the time the consecutive sentences are imposed. Those findings depend upon certain facts. How could a judge reserve consecutive sentences at the time that at times one's put on probation, when none of the facts necessary to make the findings to allow consecutive sentences have occurred yet? The judge doesn't know if they're going to occur.
Well, this is about notice, not the exact sentence that's going to be imposed. So the notice.
I understand that, but how could you even give someone notice of consecutive sentences when you don't know as a judge whether or not those facts are going to occur?
Well, the scheme, the carrot and stick scheme, anticipates violation conduct. So it's no burden on a sentencing court to anticipate that the manner in which the violation occurs will dictate that we want to give the maximum sentence available to us. So when the court is imposing notice, it is not difficult to understand that if one violates, and they violate after I make sure they understand, that I can bring the largest penalty after violation. So just the way the concept is in the statutes and what is contemplated in terms of how these situations, one on probation or community control, and then goes and violates, that in and of itself is a statutory factor already indicative to the court that this, giving them the benefit of the doubt, isn't working. That's the precise.
Counsel, do I understand that at the sentencing where someone is placed on community control, it's incumbent upon the judge to say, if you violate the terms of your community control, I will maximize the penalty, and here's what the maximum penalty will be for violating community control. Is that what you're saying?
Precisely, Your Honor, and it makes complete sense with the statutory scheme that Ohio's General Assembly has created, which is we're going to give you a chance here. If you mess up, we have the authority to bring as big a hammer as we possibly can. So when we're going to let you know that you're getting the benefit of the doubt, in our notice, we're going to let you know, here's the size of the hammer that's coming down the road. And there are 5 revised code sections.
Counsel, let me interrupt you. You're not saying that the judge has to tell them at the original sentencing that they will get consecutive sentence. They just need to tell them that there's a potential for receiving consecutive sentences in the event of a future violation, correct?
Correct, Your Honor. After the violation, the sentencing court retains full discretion on whatever the precise specified terms were held in reserve.
Okay.
And if they were to have given notice, I can impose those consecutively. They have the discretion to do so, but they don't have to.
Okay, and the original court in this case, the original sentencing court, they actually issued a sentence that was contrary to law. They said, I'm going to give you a suspended sentence of 2 years, and we don't have suspended sentences under our sentencing law. Is that correct?
Correct. No, there are not suspended sentences. There's notice of a reserved term.
But that's what the original court said to the defendant in this case when she was placed on community control, correct?
Correct.
Okay, so to put everything in context, she's on community control. She picks up a new offense in, I believe it was Jefferson County, and there's a sentencing there. And I presume the sentencing judge was well aware that she was on probation for an earlier case in the other county, correct?
Correct.
And taking into all those factors, the judge in that case sentenced the defendant to a 3-year prison sentence, correct?
Correct.
Thus losing jurisdiction of the case, the defendant was off to prison. Is that correct?
Correct.
Now the state in this case agreed with that sentence. In fact, they tried to withdraw their motion for a revocation hearing from the
Correct.
original judge, right?
Correct.
They were fine with the 3-year sentence, right?
Correct.
So the only person in our adversarial system that disagreed with that was the original judge who sentenced the defendant to community control. Is that correct?
Correct.
Okay, and so that judge brought that person back, even though the trial court had lost jurisdiction. Is there statutory authority for another court retaining jurisdiction after someone's been sent to prison?
In this context, yes, Your Honor, because of the nature of the community control statutory scheme. The offender that violates community control by committing a future felony crime is going to go back before the court that imposed community control on them. And that court is going to make a determination based upon that violation conduct, what the decision will be, further sanctions under community control or an imposition of the reserve prison term that was notified, that it had notified the offender of.
Mr. Gallagher.
Well, the state could have had a revocation hearing prior to the sentencing in the second event, right? Before the original judge.
They could have, yes, and
Right.
in practice, that sequence certainly happens.
Okay, and if that judge had imposed a 2-year sentence, then they could go to Jefferson County, and then the second sentencing judge could make an assessment as to whether, and the proper findings as to whether a consecutive sentence was necessary. Is that correct?
That's correct.
But the initial sentencing judge can't make an assessment about someone that they're placing on community control about some future event that they don't even know might happen. Is that correct?
In terms of they can't make a determination when the court is providing notice to the offender that they're placing on community control. They can't make a determination on whether consecutive imposition would be appropriate. Is that what Your Honor's question is?
Right. I mean, all they can do, all they could do at the original sentencing hearing was make a finding whether they were amenable to community controlled sanctions or a prison sentence. And they had no knowledge of what future event was going to take place.
No, but as Your Honor started this sequence, all that needs to happen is that if a violation occurs, a consecutive imposition is going to be available to the court when you're brought back before the court. So that's all that needs to be provided in the notice.
Mr. Galliard, would it be, in this scenario, she's on community control, or Brooks is on community control, Brooke is on community control in one county, commits an offense in Jefferson County, would it be appropriate for the Jefferson County judge in sentencing to prison to say, I sentence you consecutive with whatever prison time you get in the other county when they revoke your probation or your community control? Would that be appropriate?
No, Your Honor, because the consecutive imposition cannot occur unless there is a prison sentence in place already imposed. That's what 292941 says. 292941 sets the concurrent default. Felony sentences run concurrently in Ohio unless the court states that they're going to be served consecutively to a term already in place.
I understand.
Whether that be from a federal court or a different county.
It just seems that how is this that much different from what you're saying needs to be done? Because a trial court who originally sentences someone to community control is now supposed to divine that perhaps they're going to pick up another offense, perhaps even in another county or another system. And the only way that they would be able to use their discretion based on how badly they violated community control would be if they'd reserved that right to do it at the original sentence.
Correct, Your Honor. And 5 revised code sections dictate this result. 292919B4 controls the notice when community control is imposed. court decides to place the offender on community control, the court shall notify the offender that if there is a violation, the court may impose a prison term on the offender and shall indicate the specific prison term that may be imposed as a sanction for the violation. This court in Brooks read that section.
Counselor, so I guess this is one thing I struggle with. The notice is required to be of the specific prison term, right? You can't say, well, I may impose the maximum. What you have to say is, I'm going to impose 10 years if you violate, or 12 years, or whatever. So how can someone, when they don't know what the sentence could be consecutive to, notify the offender of the quote specific prison term?
The consecutive imposition is part and parcel of the specific prison term. In 292901.
Hold on. Right, I understand it, but if you don't know if it's going to be consecutive to an F1, to an F2, and as I understand specific prison term, it's a term of years that you have to tell the offender. So how do you do that when you don't know what the sentence could be consecutive to?
This notice at the front end does not have to have the number of years for the future violation.
Well, hold on. But you have to be specific, right? You can't just say I may impose up to 5 years, or I may impose up to whatever the maximum is. I mean, specific.
Correct.
We're told means a number of years. So how do you do that when you don't know what that could be, because you don't know what the sentence could be consecutive to?
All this notice is doing is it's a specific number, let's say 2 years. It's 2 years plus. That's all they have to impose. That's all they have to provide notice of. A way to look at this is if there's a single sentencing hearing and an offender is placed on community control for 2 offenses. The court imposes, let's say they're 2 F3s. The court imposes community control on both F3s and reserves 2 years on both of those offenses. And let's say that the court does not reference whether those are going to run consecutive or concurrent. Under 292941, that silence dictates that they're going to run concurrently. So the court needs to provide notice at that hearing of the consecutive imposition for the offender to leave that hearing understanding that if I violate on these 2 offenses and I'm going to serve a prison term, what I'm going to serve, if the court wants it to be 4 years, the notice has to include that consecutive imposition.
I think you're missing my question. What if you don't know what those 2? What if you're putting someone? Hold on, let me finish. If you put someone on for one offense and they pick up a new felony and the judge determines to run that consecutive, how does the judge say what that specific prison term the judge is going to impose? Because with the language, you're trying to pigeonhole all of this into that phrase, specific prison term has to be supplied. So how does the judge do that when they don't know what the maximum sentence for the new felony will be?
All the sentencing court has to do is, here's the reserved term, and there's a plus to it. It's going to be added on to whatever were to come if you were to violate through a future felony commission of a crime. And RC 292901 FF1 defines stated prison term as the prison term or combination of all prison terms. However you slice it, a consecutive imposition, whether it's 2 offenses at a single sentencing hearing, or it is a single offense at a sentencing hearing and a future felony crime, no matter how you slice it, a consecutive imposition involves 2 sentences. It's a combination of prison terms. This court's interpretations of Ohio's community control statutory scheme confirm that a consecutive imposition must be included in the notice in order for it to be imposed up after a violation. In Brooks, what this court's holding was that the offender had to leave that courtroom understanding what their prison time frame would look like. If the court wants that to look like it's going to have an add-on, They just have to provide consecutive imposition in the notice. That's it. They don't have to be able to, they're not clairvoyant. We recognize.
Counselor, please. But that's not what Brooks said, right? Brooks said you had to be specific about the number of years, right? In case you decided.
Correct.
Okay. So how do you reconcile what you're saying today with Brooks saying that you have to be specific about the number of years?
Because for any time that a prison sentence is served in conjunction with another prison sentence, whether it's, and again, this statutory scheme governs whether there's two offenses at one hearing and then there's a future violation that is not a felony of crime, or whether there's one or more at a sentencing hearing and you have a future violation. All that the notice is trying to get to in that context is, here's the exact number, plus there's going to be something more. It's not asking the court to be clairvoyant and anticipate a number on that other piece. Just,
Mr. Gallier, the FF division that you cited, I mean, don't you think the legislature meant maybe somebody's getting sentenced on two cases at the same time, rather than a case now and a case that's unknown in the future?
certainly that's the most common factual scenario, but that language, a stated prison term, includes a combination of all prison terms involved. And every time a sentencing court is imposing a prison term consecutively, both terms are involved right there in that building at that hearing. Yeah, that's undeniable. And again, the practical reality that this statutory scheme governs both the situation where there's two offenses at one time and a future felony crime illustrates that the notice really needs to be included so that we understand coming out of the hearing, like Brooks, if I violate, I know the size of the hammer that's coming. I may not know it precisely. I may not know that it's 8 years, but I know that it's going to be 2 years plus something. So I know that I have a 2 years on steroids sentence hanging over my head when I'm on community control.
Thank you. Thank you. You've used your time. Ms. Knight?
Thank you, and may it please the court. The question before the court today is if the original sentencing court has the authority, whether notice is provided or not, to impose community control violation sentence to run consecutively to the second sentence, or is that authority vested exclusively in the second sentencing court?
Ms. Knight, I wanted to ask a question.
Yes.
I mean, when you think about it, as a sentencing judge who's putting someone on community control, especially if it's an F3, but even if it's an F5, the idea that they would have to reserve the right to consecutively sentence for an offense that constituted a basis for revocation, it's almost like oxymoronic with why you'd be giving someone community control. You're almost saying that, okay, I'm going to give you community control, but I kind of think you might mess up, and you might mess up bad enough for me to want to give you consecutive sentences. So I would think the public would be saying, why did you give him community control? Can you address that?
That would be accurate, Your Honor. If a sentencing court was unable to consecutively sentence an offender if they violate their community controls and say they violated by committing another offense, as is the case here, if they were unable to do consecutively, it would be concurrent time with any other sanction imposed by another court, which would completely, negate any value that community control possesses, which is basically the state's position in this, is that if sentencing courts are not able to follow through with consecutive sentences, that they lose any and all power that they have. Any stick that exists is therefore taken away from them by negating the ability to have consecutive sentences.
Counsel, is it that difficult to give a defendant that you're putting on community control in the original sentence notice that if they pick up a new violation and are convicted of a new offense, that at that time, not only can the court impose the prison sentence on the community control case, but if the findings are made, they might be subject to consecutive sentences.
That's correct, Your Honor. That should be relatively simple to do. However, the concern and the question is whether that would provide them with exact notice, specific notice. Opposing counsel has repeatedly mentioned specific notice. This court has found that specific means the term of years.
Right, but no one could ever predict give specific notice about something that hasn't happened yet, right?
Correct.
And in this case, the state wasn't even looking for consecutive sentences. They were negotiating the plea bargain in Jefferson County and tried to withdraw the motion for a violation in front of the original judge, right?
That's accurate, Your Honor.
And if the judge would have acquiesced, then this matter wouldn't be before us today. But that judge insisted on holding another sentencing hearing and reaching the opposite of his or her colleague in Jefferson County, that consecutive sentences were warranted in this case.
That's accurate, Your Honor.
All right, thank you.
Appellee, the state maintains that the broad discretion of a sentencing court is paramount to the functioning of the justice system, and preventing consecutive sentences for imposition of sanctions on community-based control would render the community control system useless. The only punishment that would be possible for community control violators would exist for those who commit more minor violations on community control. Basically, your minor violations of not showing up, that kind of thing, that would not warrant a prison sentence per se.
So then, counsel, just let me understand, absent a minor violation, in other words, it has to be another crime committed for which a sentence will attach. And you're saying even without notice in the first sentencing, those can be run consecutively.
That's not my argument, Your Honor. My argument in this case, Your Honor, is that notice was provided to the defendant. In the 7th District's entry, they quote a section from the transcript which says, the judge saying, "I understand that if I am under community control sanction, this plea may result in revocation proceedings and any new sentence could be imposed consecutively." That language would indicate that the judge did provide, while it's minimal notice, notice that there could be the potential for consecutive sentencing.
But it's mandatory that the judge do, in the first sentencing, provide notice of the potential for consecutive sentencing with any subsequent offense.
Yes.
Okay.
Yes, Your Honor. Yes. State versus Howard provides guidance for this court on notice requirements for the imposition of consecutive sentences. In Howard, this court held that notice is to be given to an offender at the initial sentence, as Your Honor said, of potential penalties. This court further explained in State v. Brooks that the notice should be given to offenders and potential violators prior to violations. This obviously meets the scheme of carrot and stick, notifying them that if they do not follow the community control rules, that they will be sanctioned thus. If courts are not permitted to sentence community-based control violators with consecutive sentences for commission of new offenses, there's no incentive for those on community control to avoid future crimes as a condition of their community control. Appellant seems to be arguing that the imposition of reserved sentence amounts to imposition of a greater amount of time than appellant's original sentence. Appellant's community-based control carried a possible sanction of 24 months, which appellant was informed could be imposed. As I stated previously, the judge did indicate, although briefly, in the initial sentencing hearing that there was the potential for consecutive sentencing. Given that, and given that 24 months was the stated sentence, Appellee would argue that she was provided notice, albeit not thorough notice, notice that that was a potential sanction. In addition, the question includes whether or not the second sentencing court is the one that has jurisdiction to consecutively sentence. We would argue that the Harrison County Court of Common Pleas, in effect, was the second sentencing court, given that upon a revocation or a community-based control, for community-based control violation, it is considered a new hearing, it's a new sentencing, all of that. So the Harrison County Common Pleas Court was the second sentencing court, which would be able to consecutively sentence the defendant. Appellee and appellant both concur on the ability of the court to impose consecutive sentences as a sanction. Where we differ is on the amount of notice required and the specificity of that notice. The state's position is that there's only so much specificity you can provide, as many of your honors have mentioned. You can't see the future. The court won't be able to note specifically what a violation would be, especially if it's another offense.
Counsel, I seem to recall I started out asking Mr. Galliard, if the court in the first sentencing, when they're putting the individual on community control, says if you violate any terms of community control, including committing another crime for which there will be, a potential prison consequences, I will give you the maximum. And the maximum here is, 5 years, whatever. And that could be concurrent to whatever additional time is given for your new violation. Is that sufficient?
Your Honor, or Chief Justice, do you mean consecutive to?
Consecutive to the first,
Okay.
yeah. Whatever, no, I'm going to sentence you to, or I'm going to give you community control. If you violate by, committing an additional crime for which there will be a sentence, I will impose the maximum I can impose on this first sentence, and it will run consecutive to whatever the second imposition will be.
Your Honor, I think the only issue that would be presented with that is limiting the court limiting itself to only being able to do the maximum in addition to whatever.
I mean, the court can always go down, it just can't go up.
That's true, Your Honor. The state's position is that that notice would be sufficient because it would put the defendant on notice that in this case, 24 months, 2 years would be consecutive to whatever other sentence would be imposed in another case.
What you're doing here is giving notice of the worst thing that could happen if you decide not to take advantage of community control, which is what I'm offering you now.
Yes, Your Honor. Yes, absolutely.
Well, so at the original sentencing hearing, if given all the facts, the judge finds the defendant amenable to community control and places them on community control, how can they say to them, if you violate, I'm going to give you the max and I'm going to make it consecutive to whatever you commit in the future if you do that, when in fact the consecutive sentencing statute says you have to make certain findings at the time of sentencing that consecutive sentences are necessary to protect the public. So how could they do that with a future that is unknown at that time? How could a sentencing judge do that?
Your Honor, I think that would just be, as Chief Justice mentioned, the worst possible case scenario. So it's not that I will, more so it's the I can. The possibility is that if you do violate and receive a new sentence in another court, that the reserved sentence in this case could be sentenced consecutive to whatever you receive in another court. And it would potentially be important to include in that notice that would be if certain factors are met, which are required under the statute.
Right.
And then those factors could be explained or enumerated at the time of the imposition of the, at the time that the sentence is imposed.
Precisely, Your Honor. That would be appropriate, and that would put defendants on notice of, okay, if your behavior meets these specific elements, that this is very likely what's going to happen. And I think the whole statutory scheme really lends itself to that. And the idea is to provide notice to defendants what could happen.
So Ms. Knight, you actually agree with Mr. Galliard that the statute does require that notice be given at the time of the initial sentence by the first sentencing judge?
Yes, Your Honor. I believe that in this case that was achieved. I think the only issue we have at this point is whether it was sufficient. Or act.
And to help me, the statement that you read was actually read, given by the judge on the record, or it was in a form that that she signed?
It was given by the judge on the record. It is in quotation marks. It's from the plea agreement, I believe, sentencing hearing as well, in the transcript.
Oh, so it's from the plea agreement too. Okay, thank you.
I believe they were done the same day.
Okay.
So the idea behind the statutory scheme is to inform offenders of what potential consequences they face if they do commit violations of their community control. In this case, the Harrison County Common Pleas Court informed defendant at her initial sentencing hearing that any new sentence could be imposed consecutively, which put appellant on notice of the potential for consecutive sentencing for any violations. The statutory scheme in 292941 says that consecutive sentences can be served when they are only served when the prior sentence is already imposed. If a defendant is put in prison for a prior offense, the consecutive sentence can only be begun once that term has been imposed. So this court was only able to provide a consecutive sentence once the appellant was sentenced by the Jefferson County Court. The state's position is that in this matter, there may have been insufficient notice and that the proper way to correct that would be to remand for resentencing and provide the defendant with notice of the potential. The state's position is that she was provided information regarding that and that she knew or should have known, based on the comments of the judge, that there was the potential for consecutive sentencing. Thank you for your time, and the state would yield her time.
Thank you. Mr. Galliard, you've used your time. You may take a minute. You'll have, sir, you're not, okay.
The language from the plea form that the court read does not satisfy the statutory scheme. It's talking about a new offense. So the Jefferson County, it's informing Ms. Jones that the Jefferson County Court could have imposed its sentence consecutively to the 2 years from the Hancock County case. It does not inform her that the Hancock County case could be imposed consecutively by that court to the next future felony crime. The statutory scheme governing community control wants the offender to understand what this specific court will do to that offender if they violate. In order to get that accomplished, under the statutory scheme and this court's interpreting it, this consecutive imposition must be included in that notice precisely to that offense relative to a future offense, or if you have a situation where there's two offenses in one hearing, as to each other. We ask this court to so hold. Thank you.
Thank you. We'll take the matter under advisement. You'll be notified of our decision. Marshall, we call a 10-minute recess.
The court will now adjourn for a 10-minute recess.
2020-755, State X-Rail Jamie Sawalski versus Judge Robert W. Peeler. For the appellant, Mr. Pagan.
Morning. May it please the court, Madam Chief Justice, counsels for relator. Your Honors, in this case, there are three categories of arguments that I contend will carry the day for my client. And I think I neglected to ask for 4 minutes of rebuttal time, and that's what I'll do at this time. The three categories of arguments relate to procedural bar, violations of Marcy's law, and the merits question of the prohibition claim. Because Marcy's law is a new law, because I think the bench and bar would benefit from case law development on it, I'd like to focus my argument at the beginning of my argument here on the Marcy's law violations that I argue here bar the relator's claim. There are three sub-arguments here. All come from the text of Marcy's law. The first argument is that below, in the rights restoration proceeding, the victim failed to request the relief that she's asking for here. That is a bar to her claim. That argument draws specifically from the text of Marcy's law, specifically 10AB, which says, if the relief sought below is denied, the victim can take a petition. It is undisputed here that the victim did not make the claims that are being presented here. Below, the victim gave an unsworn statement that asked the court to overrule the petition for rights restoration, but made no claims about the scope of the restoration statute or jurisdiction. Based on the clear text of Marcy's law, our argument is that the relator, the victim here, has forfeited her claim, has violated Marcy's law, and you can't reach the merits because of that violation. The second specific Marcy's law violation that we have is that the rights restoration proceeding in front of Judge Peeler is not a qualifying proceeding where enumerated rights from Marcy's law can be litigated. Again, this argument comes from the very text of Marcy's law. Again, it's section 10AB, and that language says that the victim can assert an enumerated right from 10AA in any proceeding involving the criminal offense against the victim or where the victim's rights are implicated. That wasn't the type of proceeding that we had below. The proceeding we had below was litigated under 292314. That's the rights restoration statute. It was a civil case that dealt with my client's collateral disability. It was not a criminal case. It didn't involve the elements of DV. It didn't involve the DV sentence. Because it wasn't a criminal proceeding, and because it wasn't a proceeding where the victim's rights were implicated, instead, my client's collateral disabilities were implicated. We did not have a qualifying proceeding where where Marcy's law rights could be litigated and could be petitioned from. That is a second.
Counsel, was your client under a state law disability?
No.
So how does that impact the ability for restoration of rights when it is a federal disability, correct?
That's correct. So Congress passed a statute that allowed the states to lift federal disabilities under state law. That's 18 USC 921 A3 B2.
All right.
Ohio legislature enacted 292314 to lift both state disabilities that qualify and federal disabilities.
Was it the qualifying federal disability though? Was it under USC 922 G9?
Right. He was disqualified under 922 G9. All domestic violence offenders throughout the United States are. But Congress gave an escape route, which was permitting the states to undo that disability under state law as it saw fit under 921 A33 BII. The question before Judge Peeler was whether or not our legislature had intended 292314, which is the rights restoration statute, to apply to DV offenders. And there's arguments on both sides. We carried the day below. And in fact, the prosecutor and I stipulated that based on our review of the law, we believed that the General Assembly had intended for that in 292314.
Wait, you can't, can you stipulate to a legal conclusion?
I think for purposes of that hearing, we stipulated to the court that both sides believed that the petitioner was eligible.
Well, wait, so you just made up the law, right?
No, we didn't. I don't think that that's fair to say. We both presented to the court that our reading of both 292314 and Section 3 from House Bill 54 from 2011 gave DV offenders the right under the statute 292314 to make application. I suppose that it was up to the trial court to determine whether or not that was appropriate. The trial court did, and that was the posture of the case. If the victim in this case believed that that was erroneous, if she contested that particular point of law, it was incumbent upon her to intervene in that civil case, make those arguments, and take a direct appeal, which she did not do. That was her.
But you just said a minute ago that these claims didn't involve a victim. It wasn't, her victim's rights weren't implicated in this hearing. So which way is it?
No, I mean, she was a victim of the domestic violence offense, but the claim that she's making here is not a victim's right that's enumerated under Marcy's law, Section 10AA. So I'm not being inconsistent. I'm not pushing back on the fact that she was a victim, but there are certain rights in certain qualifying proceedings that victims can make, and that's where the victim has failed here, if that makes sense. Marcy's law isn't some carte blanche law that allows victims to make claims in any proceeding, in any circumstance, on direct appeal or writs. There are limitations. I've gone through some of the limitations in the Marcy's law. You have to make the claim below. That was not done here. It has to be a qualifying proceeding, which is a criminal action. This was a civil action.
So you're kind of arguing an exhaustion of remedies. So isn't there a standard of review abuse of discretion?
No. No.
On whether she exhausted remedies.
I want to emphasize again and again, this is not a standard presentment or exhaustion claim. The language from Marcy's law itself, the clear text, the unambiguous text says, if the relief sought is denied below, the victim then can take a petition. So you are, I think you as a judge are directed to that language to determine whether or not that was satisfied so that a Marcy's law claim can be adjudicated later. If not, it's been forfeited, and that's what happened here. Below at the trial, the victim, and this is another point that I want to make, the victim did make an appearance. The court let her make a statement. The statement was about the DV facts, but there was no presentation from her, from the prosecutor, that there was no jurisdiction or that the petition was outside 292314. And so that is a forfeiture under the text, the explicit, unambiguous text of Marcy's law. And honestly, that is the easiest way for this court to resolve this case, by resorting to that. Let me go on with the Marcy's law violations because I haven't exhausted them all. As I said, there was the failure to present the claim below, not a qualifying proceeding. But there's also an issue that I would characterize as standing, but it doesn't relate to the common law standing rules. Instead, Marcy's law, the text, the unambiguous text of it, has a standing provision too. And it says that a victim is permitted to assert rights enumerated in Marcy's law, which would be the 10 rights from Section 10AA. The victim in this case is not making a 10AA victim's right argument to you. Instead, in the way this case is postured, there is a claim that that the trial court below lacked subject matter jurisdiction, and that the trial court below exceeded the scope of 2923.14. That is not a Marsy's Law right that the victim has the right to assert and make claims for, either in the trial court or on an extraordinary writ like we have here. And so that provision of Marsy's Law was also violated. So let me summarize and
The
then make.
question of jurisdiction is never waived. It can be brought up at any time.
Yes, jurisdiction can be brought up at any time. I appreciate that. There's a difference between an error in the exercise of jurisdiction and jurisdiction. I think this court makes that point time and time again, and especially recently. And I think that the claim here would be that if Judge Peeler got it wrong, he got it wrong in the exercise of his jurisdiction and not the power to hear the case itself. It is absolutely 100% undisputed that the legislature, the Ohio legislature, gave trial courts the power to remove disabilities under 2923.14. That power is there. That was the power that Judge Peeler was exercising when he made his determination to restore my client's gun rights. If he made a mistake and Congress had not intended for that, that's a mistake in the exercise of jurisdiction, but not the power to hear the case or decide the case in the first instance, which is what prohibition asks. And before I leave my Marsy's Law argument, I do want to make clear that the purpose, the intent, the spirit of Marsy's Law was completely honored in this case, despite the fact that it was a civil restoration trial, and we did have a trial. The Warren County prosecutor notified the victim was present, the victim was heard, the victim was allowed to give an unsworn statement free from cross-examination in opposition to my client's rights restoration, and Judge Peeler listened to and used the victim's statements in making his decision. She was given notice, respect, all the enumerated qualified rights from Marsy's Law and 10AA were complied with. What the victim is trying to do here is make legal claims like parties make about jurisdiction, statutory construction, and the scope of a statute. And Marsy's Law was never intended to give victims that power, especially the power to make decisions about legal issues over and above what the state prosecutor and I decided and the judge decided were appropriate. Because if Marsy's Law is extended that way, then what you're going to find is that victims will be making claims about in motions to suppress in criminal cases, or making arguments about jury instructions or lesser included offenses. And Marsy's Law was not intended to give victims that authority and that power, but that's what's really being done here. I've completed my argument about Marsy's Law. Again, if you're going to make a Marsy's Law claim, you have to comply with Marsy's Law, and Marsy's Law was not complied with by the victim in the three ways that I've enumerated. There's also a procedural bar that relates to res judicata. If you remember from the facts of this case, Judge Peeler's decision was a final decision. There was no appeal, and this extraordinary writ application is a collateral attack on a final judgment. We believe that res judicata would also be a procedural bar here. And then if I could address the prohibition.
You're saying she should have intervened as a party under Marsy's Law so that she could appeal to avoid res judicata, right?
I'm saying that she should have intervened under Civil Rule 24, not under Marsy's Law, because it was a civil action, and she was given the authority under Civil Rule 24 to intervene, to become a party, and to make the very arguments that she's making here. She sat on her rights. She didn't do that. She was disappointed by the decision and is now seeking extraordinary relief when there was an adequate legal remedy at law, intervening in the civil case and making those claims on direct appeal,
So
which I
she
think
should
would
have
be able to make
intervened
if
in an
she,
action where the judge did not have the power to act, right?
sorry,
She should have intervened in the action where the judge didn't have the power to act, except to deny it, which he didn't do. And basically, that's what you're saying. And so,
no, I'm saying if she has a claim, if she had a claim about the scope of 292314 and whether or not it extended to DV offenders, and if she had a claim about jurisdiction, and she was put on notice because she was that the state was not going to make a jurisdiction argument or a scope of the statute argument, that she had the right to intervene and make those claims because she was an interested party. But she did not do that. And she should have. Because that's an adequate remedy of law. I mean, I think now that argument now is moving towards the merits of the prohibition claim.
and so one last thing on this. So
Sure.
what would be her interest in intervening? Would it be under Marcy's law, or would it be as a victim? What would be her interest that a judge could grant either permissive joinder or mandatory?
When she gave her statement, I won't say testify because she didn't testify. She wasn't subject to cross-examination. When she gave her statement, she expressed what her interest was, and she claimed that my client was not a suitable person for gun restoration.
No, I'm saying legally, what basis would she offer for why she should be permitted to intervene in that civil action?
Well, and I'm explaining that. She was coming out of a divorce with him. She felt threatened by him. She did not want him to have a gun. She has a right under Marcy's law to, reasonable safety. She didn't think that he was a suitable candidate for the judge to balance the factors and find that he's been rehabilitated. And that was her interest, to oppose his gun right restoration.
So her interest was because of Marcy's law, right?
Her interest included a potential Marcy's law claim.
Thank you.
Thank you.
I'll reserve the rest. Thank you.
You've used your time. Okay, we'll start with Ms. Well.
Thank you, Chief Justice, and may it please the court. My name is Elizabeth Well, and I represent Appellee Jamie Sawalski. I want to start with a point that Mr. Pagan just raised because I think it really goes to the heart of this matter. All of these issues are somewhat tied in together, whether she had standing, whether she should have intervened. And I think to answer those questions, as Mr. Pagan said, we look to the plain language of the Marcy's Law Amendment. The plain language provides explicit standing for Ms. Sawalski. And the rights that she asserted pursuant to that plain language were the rights under 10AA to safety and reasonable protection. As Mr. Pagan just described, Ms. Sawalski was notified of the underlying trial court proceeding. She attended that proceeding, and we can assume, although the record isn't clear, that the reason that the prosecutor provided her notice and the reason that the court allowed her to be heard is because there was some acceptance there that her rights as a victim were implicated in that proceeding. And the criminal offense was absolutely involved in that proceeding because but for the criminal offense, that proceeding never would have taken place. There would have been no need for Mr. Ewing to seek relief from a disability if he had never been convicted of domestic violence in the first place. So when we look to the plain meaning of the constitutional terms like assert, which is to say that something is so, Ms. Sawalski attended the trial court proceeding and she let the court know that she was concerned for her safety and reasonable protection if Mr. Ewing, who was convicted in a trial of domestic violence against her, was able to use, obtain, and possess firearms. All Marcy's Law requires is that, an assertion at the trial court level on the part of the victim. It doesn't require a sworn statement. Many of our appellate courts have taken up this issue already. And as we know, most victims are not going to have counsel, especially not at the trial court level. And so when the Ohio citizens passed Marcy's Law, there was an acknowledgement of that, and then an assertion to be sufficient under Marcy's law only needed to be saying something is so. That's the plain meaning. And of course, in that proceeding, as I said, her rights were absolutely implicated. Anytime we look at returning firearms to a domestic violence offender, a victim's right to safety and protection are going to be implicated there. And of course, the criminal offense was involved. So I think it's unquestionable here that Ms. Sawalski had standing. And I would note too, on the res judicata issue, that there's nothing in the constitutional amendment that would require Ms. Sawalski to attempt to intervene. She is only required by, as Mr. Pagan admitted, the plain and unambiguous language of Marcy's law to attend to assert her rights. And then when her rights were denied, which they were by Judge Peeler, she has the right to petition the appellate court for review, which is exactly what she did. And she prevailed in the 12th district, and the court issued a writ of prohibition. I want to quickly also talk about the fact that not only is one element of res judicata missing here, but all the elements of res judicata are missing here. And then I will concede the rest of my time to my co-counsel, Michaela Deming, who will answer any questions that you may have about the merits of the prohibition issue. But as to res judicata, there was no valid judgment on the merits here because Judge Peeler acted outside the confines of 2923-14. As some of the questions we're getting to during Mr. Pagan's argument, 2923-14 specifically states that a trial court cannot relieve a disability, especially because this is not a state disability, when someone is otherwise disqualified. Because Mr. Ewing is federally disqualified, the trial court did not have the ability to act as it did. So there's no valid judgment there. Secondly, there's no privity.
Let me interrupt you. Just
Sure.
assume that we agree that the judge didn't have the authority to do what he did. But we think that that's an error in the exercise of his jurisdiction, not that he didn't have jurisdiction. And assume we also think that under Marcy's law, she had a right she had a right to appear, which she did below, and then she had a right, which Marcy's law said, to petition the Court of Appeals. Then how do we look at it? Can she raise arguments she didn't raise below? Help me with that.
Well, absolutely, Your Honor. I think that there's a slightly different standard here because at the time that Ms. Sawalski filed her writ in prohibition, the prevailing case law around the state said that victims were not parties to the case and as such were unable to appeal. Obviously, since then, we got this court's decision in State Ex Rel. Thomas versus McGinty that said in some situations it would be appropriate for victims to appeal. But at that juncture, only writs were available. And I think the standard for writs is a little bit different than a direct appeal. She's not a party. She doesn't have the ability to object. And I think the other piece of it, as Justice Bruner said, is we have an absence of subject matter jurisdiction here, and that can be raised at any time, and that isn't waivable.
Well,
so I think,
but I guess my premise is, if I don't think it's subject matter jurisdiction, I just think it's an error that the court made in the exercise of its jurisdiction, and because the statute gives the judge the authority to remove fire disabilities, the judge had jurisdiction, he just applied it wrongly. What then?
I understand the premise of the hypothetical, and respectfully, I disagree about the subject matter jurisdiction piece. But I think that the other thing that we have to consider here, and I think that this court maybe grappled with this in State Ex Rel. Thomas versus McGinty, is that the Constitution guarantees victims the right to seek appellate review when their rights are violated at the trial court level. There has to be a remedy. If this court, in the hypothetical, acknowledges that Jamie Sawalski was a victim, she had these rights in the trial court proceeding, there has to be a remedy for her to seek appellate review, especially in a scenario like this one, Justice DeWine, where you have Mr. Ewing pursuing an avenue that isn't available to him anyway. And had he pursued an avenue that was available to him under federal law, which is a pardon, the statute that discusses pardons in Ohio absolutely would provide the ability for Ms. Sawalski to petition for review, because that is soundly within the criminal statutory scheme. And so I think given all of that, if the court truly doesn't believe that subject matter jurisdiction is lacking, and I disagree with that, I think that this case is very similar to State ex rel O'Malley versus Collier-Williams. But if this court doesn't agree with that, there has to be a remedy under Marcy's law for victims like Ms. Sawalski. So going back to res judicata, Mr. Ewing also claims that Ms. Sawalski is in privity with both the state and the trial court judge. But the mutuality of interest that this court deems the hallmark of privity is completely lacking here. Both the judge and the state, as Mr. Pagan said, conceded or stipulated away any error in subject matter jurisdiction or defect in subject matter jurisdiction, and agreed that the court could do this, even though that was a legal conclusion. So Ms. Sawalski disagrees with that. That's the genesis of the writ in this case. And so she's absolutely not in privity. And, you know, as we just discussed, she couldn't have raised these issues at the trial court level, because as a victim who was unrepresented, she could not have foreseen that the trial court was going to act outside its judicial authority and make a decision to relieve Mr. Ewing's federal firearms disability, even though that's impermissible under federal and state law. And finally, these two cases don't arise out of the same transaction or occurrence, because the trial court matter arose out of the application, which was unlawful in and of itself, and the appellate matter arose out of Judge Peeler's unlawful response to it. So we really feel Ms. Sawalski absolutely had standing, both the trial court and the 12th district, to seek the writ of prohibition, and res judicata doesn't bar this court's review. I am going to now cede the rest of my time, unless there are any questions for me, to my co-counsel Michaela Deming, who will address more about the merits of the prohibition issue.
Ms. Deming?
Thank you, Chief Justice O'Connor, and may it please the court. Ms. Sawalski's prohibition action must succeed because Judge Peeler did lack subject matter jurisdiction to relieve Mr. Ewing of a federal firearms disability. Ohio's legislature has seen fit to not restrict the civil rights of misdemeanants like Mr. Ewing, and therefore Ohio cannot relieve the federally imposed disqualification. As we have heard, it is undisputed that Mr. Ewing was convicted of domestic violence misdemeanor the first degree. It is undisputed that his conviction is a qualifying domestic violence offense under federal law. And it is undisputed that the federal firearms prohibition under 18 U.S.C. 922 G9 applies to Mr. Ewing and is the sole source of his firearms disqualification. It is further undisputed that Mr. Ewing did not get his conviction expunged or set aside and did not request or receive a pardon. The only potential source of dispute that opposing counsel is raising here is in regards to this application of 292314 to Mr. Ewing. Because the Ohio legislature chose to not revoke the civil rights of domestic violence misdemeanants, Judge Peeler lacked the jurisdiction to restore that federally taken firearms right. This was made clear in the case by the United States Supreme Court in Logan v. U.S., as well in the Sixth Circuit in U.S. v. Bridges. The remaining arguments that have been raised in the brief have all also been soundly defeated in the federal courts, including the Sixth Circuit repeatedly. What Mr. Ewing is asking this court to do is to override the will and the actions of both the Ohio legislature and the U.S. Congress to create a new remedy for him out of whole cloth. If Mr. Ewing wants to legally obtain or possess firearms, he must seek and be granted a pardon, or if the option under 925C is reopened, apply to ATF or pursue a remedy in federal court. And for those reasons, we ask that you affirm the 12th District's decision.
Thank you. Mr. Pagan, you've used your time, I believe. You may take a minute.
Thank you for that. What my opponents have not raised is that they want you to decide this on the merits. This is an extraordinary writ case. It's a prohibition case that decides jurisdiction and not the merits. Second, my opponents absolutely failed to address the three arguments arising from Marcy law that show that the claim is barred. They didn't request the same relief here that they requested that was brought up below.
Counsel, if Judge Peeler exceeded his authority. Where does that put you?
That puts me at a circumstance where, as Justice Dewan said, there potentially is an error in the exercise of jurisdiction, but not subject matter jurisdiction, especially when it's clear that Congress said to states, you can do this. You can remove disabilities. Our General Assembly said you can.
Well, yeah, they said that, but under the statute, 292314, he doesn't qualify.
Well, he does. He's not specifically prohibited under the statutes that. There's nothing in 29. I disagree with that. There's nothing in 292314 that says it's disqualified. And then what we haven't talked about is the legislature's uncodified intent that's reflected in Section 3 of House Bill 54, where they say the General Assembly is explicitly making this amendment to clarify that relief from a weapons disability granted under 292314 restores civil firearm rights to such an extent that the Uniform Federal Ban on Possessing Firearms does not apply. That is a clear expression of intent that it would extend to DVs. That is why Judge Peeler and I and the state prosecutor, reading that language, believe that it did extend to it. So while there's arguments on both sides about whether or not it extends to a DV, in order for my opponents to win, they have to show no debatable, unambiguous lack of subject matter jurisdiction. They did not take an appeal here. They talked about appellate rights in their argument. There's no appeal here. There was a final judgment from which they didn't take an appeal.
So you're basically saying that the state gun disqualification laws specifically doesn't apply to DV, but if the trial court wants to go ahead and disconnect that disqualification somehow through that language in House Bill 54, it does, right?
I didn't specifically follow your question, but you started off by saying that there's a state firearm disqualification for DVs, and that's not true. There's not one. There's only a federal.
I said it doesn't exist, but I'll leave it at that.
Okay, thank you.
Thank you. Thank you. We'll take the matter under advisement. You'll be notified of our decision. Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.